So hello, welcome to the Debrief. This is a legal podcast. My name is Dan Pinder. I'm an associate solicitor in the wills and probate team at Napthens. I'm joined by my colleague, Veronica Howley, who's a legal director in our litigation team. In this episode, we're going to be talking about the often emotional subject of contentious probate. And we'll look at how people should approach probate scenarios when disagreements arise, and look at the options available to them to bring resolution to contentious matters. Now, Veronica, what is contentious probate?
Contentious probate is the area of law that covers disputes about estates and about the administration of estate. And the contentious word means simply that it usually involves court action. So, simple.
Yeah, I think from my side, so I mainly deal with the non-contentious side of probate, so acting for executors or personal representatives. And we often hear from beneficiaries saying that they feel they should have got more from somebody's estate or somebody's will. What sort of action could that person take?
It's a common complaint or concern when somebody dies and the people who are left behind, their loved ones, find that their estate isn't left quite the way it should be. Now, that can happen either because they've not made a will and the law doesn't provide for them. So, for example, the best example I can give you of that is a cohabitee. They don't have any legal right to anything from the estate, generally. Or the other scenario is if a will is made and it makes provision in a way that the beneficiaries or would-be beneficiaries were not expecting, and it can come as a shock. In those circumstances, the most common kind of challenge that certain categories of people can bring would be a claim under the Inheritance Provision for Family and Dependants Act 1975, which is a bit of a convoluted title, but we call that the 1975 Act. Okay. And that allows certain categories of people, not anybody, but close family members and loved ones of the deceased, to bring a claim for financial provision from the estate. And the first category of people is spouses or civil partners, and they have the highest status, if you like, because they have a right of support. But then cohabitees can bring a claim as long as they've lived with the deceased for 2 years continuously before the date of death. They get in as well. Children of the deceased, and although that can categorise any child, so it could include adults, it's really geared more at either children or adults with some kind of special relationship to the deceased. And it also includes children of the family, which could include stepchildren. It also includes people who were financially dependent on the deceased before they died, but that category is what we call a bucket category, into which a claimant might drop if they don't fit into the other category. So some people can bring a claim.
Yeah, no, I think it's a really interesting piece of legislation, and clearly sort of goes to give that certain category of people options. I think one of the main documents that I look at is somebody's will, and a will gives instruction on somebody's executors, and also their succession as well by way of inheritance. Do people have any options in terms of challenging a will's validity? Oh,
yes, and it's becoming more common now as people are living longer and they are living with more ill health, dementia, and dementia-related conditions such as Alzheimer's are on the rise. And so the circumstances in which a challenge may be brought to a will are increasing simply because people have different types of capacity to make different decisions. And the capacity to make a will is actually a fairly low bar, and it's governed by a very old case called Banks and Goodfellow. And that broadly says that as long as you know, you can have a mental illness or you can have some physical illness that affects your mental capacity, but as long as you know roughly what your bounty is, how much you've got in your estate, you don't have to know it to the penny, and roughly who you might be expected to benefit from your estate, even if you decide not to benefit those people, and you're not affected by a disease of the mind that would affect your ability to rationalise that decision, then you've got enough capacity to make a valid will. And usually the solicitor who would make a will for that individual will take a lot of care and a lot of time with that individual to make sure that they do understand the nature of what they're doing, that is making a will. But in circumstances where that is open to challenge, then the will is open to challenge as well.
That's really interesting. I think clearly from what you're saying, we're seeing sort of this collection of factors, both in terms of beneficiary needs and also the person who's making the will at the time, sort of coming together, creating this sort of complex mix of issues. And it's important to take advice when sort of issues arise.
Oh, that's for sure, yeah.
I think sort of on that point, when something contentious happens, what sort of steps should someone be taking themselves?
Well, we can say that if we can sort of categorise the main things that contentious solicitors look at, there's a sort of remedy and a fix for most of them, but they go along the same sort of path. So we'd be looking at, as you've said, challenges to a will is an increasing growth area, and it's potentially expensive, so it's good to look at alternatives. 1975 Act claims, but there are also circumstances such as people who have concerns about executors managing an estate or personal representatives. They may want them removed under certain circumstances, and for executors themselves, if they're administering an estate and they come across a brick wall, if you like, an impediment, a problem that means that they can't administer, then court action can be taken, but it's always the last resort. First port of call is always going to be try and see if you can sort it out. Speak to the person who is either the executor or another beneficiary or somebody with an interest in that estate, who might be the person who's blocking what you want to do or where you think something is fair or not, and see if you can come to an agreement. Now, it's always advisable to do that, but with contentious estates, it's quite emotional. It can be quite difficult. And sometimes, if it gets difficult, it might be easy to see a solicitor for initial advice, have a chat about what you can do. If you can't resolve it between the other individuals concerned, then we may need to start corresponding with the other side under something called the pre-action protocol.
Okay.
There's a pre-action protocol for every different type of claim, really, or a general protocol where one doesn't apply. And it's simply a posh way of saying a letter before claim stating what you think the problem is, the opportunity to provide the evidence that supports what you think the problem is and how it needs to be fixed. And it gives your opponent the opportunity to respond. And you might, through the pre-action protocol, get some form of settlement. Might not always get you everything you want, but it will get to a settlement which sorts it out without court proceedings. Or you can try things like alternative dispute resolution, making offers, mediation, or joint settlement meetings to try and see if you can thrash things out. But if none of those work, and the only alternative is court action, then we help you with that, and we take you through the right process for the right type of case you've got in order to get, hopefully, the right result for you.
Yeah, I think it's a really good point, Veronica, and I think we don't forget that this is a really emotional time. It's a really sensitive time for clients, and I think by taking early advice, trying to form a strategy between sort of a contentious side and non-contentious side, it really puts the client in a position where they can sensitively get advice and find a solution that works for them.
I think that's important, where you're saying that sort of coordination between the non-contentious side of things and the contentious side of things is important, because one of the things that we have to think about really carefully is that we're dealing with human beings here. We're dealing with human beings going through a grief process that is difficult, and everybody's perception of grief and how they feel it is different. And in circumstances where something might have gone wrong with a will, or where there's not proper provision made, it's incredibly distressing and emotional. And we have to be attuned to the fact that we're often dealing with families. We're looking at, well, the way we deal with things can either help or hinder. Sometimes it can actually save the family relationship, should it be savable. Certainly what we don't want to do is go in and make things worse. So there's a very particular way of dealing with contentious probate claims that is probably at odds with what people think litigation is. It's a completely different way of dealing with things.
No, I think you word it very well, Veronica, and I often see on the non-contentious side of probate, perhaps two executors who are appointed in a will. They might not agree, but they like having that independent advice, and they like almost having that neutral party.
That's a good point, actually, because one of the things that we see, and which you obviously see but can manage to resolve things and smooth things over within your role, I tend to see it when it can't be smoothed over when there's a problem. And the issue with executors is if there are multiple executors, so two or more, they all have to agree. There's a requirement on them to act unanimously. So all decision-making has to be unanimous. If two parties can't agree, and quite often this happens where it's siblings, non-professional executors, siblings are often appointed as joint executors in a will because the parents think, oh, well, that's going to be the best thing, you know, Jilly and Johnny are going to do that and it's going to be fine. But if they don't get on or they've had a falling out, that can frequently spiral and it reaches its sort of most difficult point in decisions, sometimes quite trivial decisions about the administration of the estate. Small points such as, well, important for them. Well, who's taking the ashes? How are the ashes going to be split? How are they going to deal with the burial? Administering the estate from things like closing the bank accounts, selling property. Does it need to be done up to sell it as it is? All of these things can spiral if they're not smoothed over. In most cases, that will work and it will fix. It will just resolve itself for the greater good of getting the estate dealt with. But if it doesn't, and if something goes seriously wrong, say, for example, you get one executor who will not step up to the plate and help administering the estate, or who is living at the property that belonged to the deceased and won't allow it to be sold, well, you're stuck. In certain circumstances, we can help executors to make an application. Quite often it's to remove them both and put the estate administration into the hands of somebody independent to simply get it done. And courts are very keen to make sure that the wishes of somebody who has made a will or who's left an estate the way they've left it, that those wishes are carried out or that the estate is administered. So it's not necessarily an easy task to do. You've got to make sure that a court is satisfied that the estate can't be administered, but we can take action to help with that as well. Hopefully we never have to do it, but it is a remedy that's there.
Yeah, no, I think it's a good point, and I think if sort of all parties involved can sort of try and stay as calm as they can in this situation, everyone can take some practical advice and look at the steps available to them. What is already a difficult time can be made hopefully a little bit easier by our assistance.
Well, you would hope so, because part of the work that we do, certainly within mixed practice firms like we have, is that we work together in a coordinated way to make sure that between the contentious side and the non-contentious side, the client's hand is held all the way, if that's the right expression, that they're looked after, and that their understanding from us is what they can do, what they can't do, and solutions to problems that might seem intractable or might seem difficult. We can often help them find another way of looking at it or of dealing with it that hopefully avoids them having to go to court. Because most cases, although I'm a contentious probate lawyer, it's very rarely necessary for me to attend a trial. Most cases will settle, and quite often it will settle on the basis of things that the parties can try and agree between themselves. Sometimes we can come up with quite novel solutions to what seemed to be a black and white kind of problem, and that gives certainly me a great deal of satisfaction if we can do that.
I think being able to break those deadlocks. Often I speak to clients just before they take more contentious advice and they're worried and they're concerned and they assume they're going to end up in court. But I think having those options are often surprising, like mediation, joint settlement meetings, actually drawing up a settlement agreement. I think it's important people recognise those are viable options available.
They're really effective. They're being they're popular with lawyers because we know how much cases can cost. They're popular with the courts because it means if cases settle, our overburdened courts have one less case to have to make a decision on. But they're actually really good for the parties, whichever side of the argument you're on. And the reason that they're good is that they put the parties in control of how that case is settled. And particularly if it's a mediation, there can be all kinds of things that come up on the day. There aren't things that a court would have the power to order, but they might actually unlock the solution to the problem. It keeps you in control of how the case is settled, and it saves an awful lot of money on legal costs. And the sooner you can do it, the better, really, and we can help along the way. But ultimately, it's about avoiding a decision being imposed upon you.
Yeah, and I think it's a brilliant point, sort of someone having that input, almost that control in the process, but also the process delivering an outcome that they want. And I think really on that note, thank you, Veronica, for joining me to look at contentious probate and some of the practical solutions available to people. It's a difficult time to navigate without other problems, and it's good to know that there are resolutions available. If you would like to find out more details on the support Napthens can provide, both with non-contentious and contentious probate, please visit our website and we'd be happy to help. Thank you for listening and watching and joining us on the debrief.